Ladies and gentlemen, welcome to Civil Justice Subcommittee for April the 2nd, 2025. First order of the day is roll call. Members, please sign in and signify that you're present. And Madam Clerk, please take the roll.
Mr. Chairman, you have 6 members present. You have a quorum.
Thank you, Madam Clerk. Members, we do have a quorum. Is there any personal orders today? Personal orders. Seeing none, we'll jump into the calendar real quick. We'll start with the firearms calendar. Item number 1, House Bill 873 by Representative Fritz. Do we have a motion and a second? We got a motion and a second. And Representative Fritz, I do show an amendment. Would you like to go with that?
Yes, sir, Mr. Chairman. Thank you. 4178.
That's what I showed. We got a motion, and do we have a second on amendment 4178? We have a second. All right. All those in favor of adding 4178 to House Bill 873 signify by saying aye. Opposed, no. The ayes prevail. Representative Fritz, you're on the bill as amended.
Thank you, Mr. Chairman and committee. I bring before you Bill 873, which is protecting Tennessee firearms industry from foreign threats of lawsuit. This legislation makes additions to the law that the General Assembly passed in 2023. I had the privilege of carrying that extended protections of the Federal Protection of Lawful Commerce in Arms Act to the state level. These additions protect firearm manufacturers from foreign claims of civil liability. And when I say foreign, not just international foreign, but other states. State courts would be blocked from recognizing foreign judgments. It also expands the list of manufacturers to which this legislation would apply. As you're likely aware, the country of Mexico has filed suit against several firearms manufacturers, some who manufacture here in Tennessee. Smith & Wesson is one of those, claiming that they should be held accountable for the arming of the violent cartels in Mexico, which I think is ridiculous. While the Supreme Court has stated that it will hear this case in October of 25, if we do not address these types of lawsuits at the state level, these lawful businesses may be vulnerable. According to the Tennessee Department of Economic Development, in September of 21, Tennessee was the #1 per capita in the nation for employment in the firearms and ordnance industry, employing 8,000 people. The industry contributes an estimated $1.1 billion to our economy each year. There are, by my count, 20 firearms and ammo manufacturers in the state, and those include Smith & Wesson, Beretta, GS Performance, who many of you know make Glock parts. These companies have moved their headquarters here and their operations because we have a business-friendly economy. Just recently, it was put out that Barrett is going to invest another $75 million in Middle Tennessee in this. Passing this legislation not only protect these companies and those good Tennesseans that work for those companies, but it puts our state in a position to recruit further in that industry. And so, with Mr. Chairman, with that, I'll ask for your favorable consideration, answer any questions you may have.
Thank you, Representative Fritz. And we do have somebody testify. Is it okay to go out of session? All right. Without objection, we'll go out of session. And Drew Spiegel, if you'll come down and have a seat up here, and you'll see the little red light come on. If you'll just say your name and if you represent anybody, and you'll have 3 minutes. And you are recognized.
Hello, my name is Drew Spiegel.
If you would, yes, sir.
Awesome.
Thank you.
Hello, my name is Drew Spiegel, and I'm here representing Students Demand Action. Good afternoon. My name is Drew Spiegel, and I'm a sophomore at Vanderbilt University. I've been an advocate for gun violence prevention since surviving the 4th of July parade shooting in Highland Park, Illinois. I was there that day when 7 people were shot and killed and 48 more were injured. Today, I help lead the Students Demand Action chapter at Vanderbilt. I'm here today because I strongly oppose this bill. After the Highland Park shooting, fellow survivors decided to sue Smith & Wesson for misleadingly marketing the M&P 15 used in the shooting as associated with the U.S. military, which is, of course, what the M in the M&P stands for, military. This marketing practice sells an image that caters and attracts individuals like the shooter. Additionally, survivors sued the 2 gun retailers, online distributor Bud's Gun Shop, and retailer Red Dot Arms for negligently and illegally selling the murder weapon. My fellow survivors deserve their day in court. The legislature should not be intervening to protect bad actors from being held accountable for the devastating consequences of their own actions. Victims deserve fair access to justice, and creating additional hurdles that prevent accountability runs counter to that. Plain and simple, it does not make sense to exempt gun manufacturers and sellers from following the law. Giving a gun to an individual in crisis or with violent intentions is not an action that can be lightly dismissed. It is in part what caused the shooting I experienced at Highland Park and the shooting at Nashville's Covenant School, as well as so much of the gun violence that claims over 45,000 lives every year in America. Tennessee already protects gun makers and sellers from civil liability claims to a greater extent than the existing federal protection of Lawful Commerce and Arms Act, also known as PLCAA. PLCAA itself provides gun makers and sellers a distinct legal immunity that far exceeds that of other industries. By further absolving the gun industry of any duty to act responsibly, this bill gives further protection to bad actors and puts Tennesseans in danger. I strongly believe in law and order. That means letting courts determine whether or not the gun industry is following state laws. If gun manufacturers and sellers are already abiding by state and federal laws, great. They do not need the government to step in and protect them more. If not, there should be no special privileges that allow them to evade accountability. Holding bad actors in the gun industry accountable instead of protecting them would save lives. To conclude, I strongly urge the committee to prioritize the well-being of Tennesseans over the profits of the gun industry. Together, we can prevent tragedies like those in Highland Park and that Covenant from ever happening again. Thank you.
Very good presentation, Mr. Spiegel. Any question? Representative Johnson, you're recognized.
Thank you, Mr. Chair. It's interesting because I just came from another committee where they were trying to give immunity to a corporation who was causing harm to people. And so I think that your point is well taken, that if a company is doing right and not causing any harm, let the legal process take care of that, and they shouldn't have any extra government protections. Is that what you're saying?
Absolutely.
And you're all
Okay.
free to go back and forth.
Thank you. I guess, so for me, it's anytime there's a frivolous lawsuit, it is, it's thrown out. My concern is when you take multi-million dollar, billion-dollar corporations and remove regular citizens' ability to challenge their company if they feel that they were harmed. I think that we are setting a horrible precedent if we allow these multi-billion-dollar companies immunity from just the average citizen being able to redress their concerns. So thank you so much for your testimony, and I think it's a great example of how we should just let our legal process work and not give protections to billion-dollar companies. Thank you.
Any follow-up, Mr. Spiegel?
No.
Thank you. And we don't have any other questions, so we appreciate you coming down here today. Thank
All right.
you.
Thank you.
Members, we'll go back in session. And Representative Fritz, you're recognized. You have any follow-up before we vote?
Thank you, Mr. Chairman. I would just offer that with a smile on my face, a Sun Tzu quote or a George Patton quote. I don't remember where I read it, but no fixed position is ultimately defensible. And unfortunately, there's such a move of an anti-gun movement in the world today, in America today, that will exhaust any opportunity to put these legal, lawful, productive businesses out of existence. We saw that with Remington not too long ago. And these lawsuits don't have to be successful. They don't have to win the trial. They become death by 1,000 paper cuts. And 8,000 Tennesseans depend on this work. Our Second Amendment rights depend on us being able to acquire firearms. So with that, I would again ask for your favorable consideration, members. Any other questions?
Thank you. I don't have anybody on our list, so we're voting. Representative Johnson, you're recognized.
Thank you. I guess to that, I would say not necessarily anti-gun, but just anti-gun violence and pro-safety and pro-protecting our communities. So, it's that's not necessarily, it's not a black and white line there. My gun happens to be a Smith & Wesson, and I certainly respect the right for folks who are going to do right to have those weapons. But I think we also, as our Tennessee Constitution says, reserve the right to regulate our guns for the safety of our community.
Representative Fritz, any follow-up?
No, thank you, Mr. Chairman.
All right, members, we're voting to send House Bill 873 to full judiciary as amended. All those in favor signify by voting aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Madam Clerk, takes a vote.
Mr. Chairman, you have 5 ayes and 1 no.
The ayes prevail. House Bill 873 is full judiciary as amended.
Thank you, Chairman, Committee.
Thank you. Members, we're going to jump to the regular calendar one. I've got to go present a bill, so I'm going to take care of Chairman Farmer's bill. Item number 5, House Bill 487. Do I have a motion? We got a motion. Do I have a second? I need a second. Going twice. Okay, we got a second, and I do show an amendment, Chairman. Would you
Yes,
like
Mr.
to run
Chairman,
that?
and I believe we're going to be looking at House Amendment 5430, and it rewrites the bill.
That's what I've got too. Members, do I have a motion and a second on the amendment? And we got a motion. Do I have it in a second? All those in favor of adding 5430 to House Bill 487 signify by saying aye. Opposed, no. The ayes prevail. Chairman Farmer, you're recognized as amended.
Thank you, committee members and Mr. Chairman. I had this was brought to me by the Court Clerks Association. What this does, this allows for a $2 increase, a civil assessment on the civil and criminal cases that's filed in those clerks' offices. They provides for the more training, and this hasn't been adjusted over the past 2 decades, over 20 years. So that's what this does.
Thank you. We got a question on the bill. All those in favor of sending House Bill 487 to judiciary full signify by saying aye. Opposed, no. Let's do it on the board. How about that? All those in favor signify by voting aye. Those wish to oppose, vote no. Has every member voted? Does any member wish to change their vote? Madam Clerk, takes a vote.
Mr. Chairman, you have 6 ayes and 0 noes.
The ayes prevail. House Bill 487, full judiciary as amended. Next up, item number 6, House Bill 11. I do show in the memo.
Thank you, Mr. Chair. If we could use House 2 or 3 of them in there, but this is the latest one, 6898.
All those in favor, well, actually, do I have a motion and a second? We got a motion and a second. All those in favor of adding 6898 to 1120 signify by saying aye. Opposed, no. The ayes prevail. Chairman Farmer, you're recognized on the bill as amended.
Yeah, thank you, members. Mr. Chairman, what this is the Modernizing Tennessee Foreclosure Act. What it does is brings us to a situation where it's kind of a phase in from right now. The foreclosure notices are in the papers, like the hard copy papers. Of course, the papers they also have the online versions. Of course, you have to pay for it. What this does would take, and over the next 2 years, it would phase out having those papers, having to run those foreclosures in the papers and move it to online, in hopes that by that point in time, the newspapers can still do so by allowing folks to access their pay sites for free. At that point in time, this would reduce costs for folks. They're in tough spots. Frankly, foreclosure ads are fairly expensive. They charge by the word, sometimes the letter, and that cost is then passed on to a person who's in foreclosure, probably for financial reasons, sometimes other reasons. But it's a pass-through cost that just kind of ends up in the hands of these homeowners that are already in those tough financial situations. So I think it's good policy, and I think it's good that we allow the papers to continue to do kind of operate how they're operating for the next couple of years. By that point in time, to give them time to stabilize and figure out a route moving forward. So I mean, everything's online now. It's moving that direction. We all have iPhones and find everything we need to know, and all the truths on the internet. So, Mr. Chair, members.
Great explanation. And we do have testimony. Without objection, we'll go out of session. Mark Millsaps and David
And it's really not.
Gord.
That was a joke.
Gold. Yes, sir. And is Mark Millsaps here? Okay. You both come down and just, we'll start
These are
with
paper people.
you. If you'll just state your name and who you're with, and then you'll have 3 minutes.
Okay, thank you. Good afternoon. My name is Dave Gould. My company, Main Street Media of Tennessee, is headquartered in Gallatin, and we publish 16 local weekly newspapers in Middle Tennessee. And I'm here on behalf of the 130 members of the Tennessee Press Association to share our strong opposition to this bill. Taking foreclosure notices to one time in print, which this will do in 2 years, will significantly decrease the number of people who are going to see the notices. People still read the print version of our newspapers, and they know exactly where to find legal and foreclosure notices. In many of our rural counties, some people do not have reliable internet access yet. They read their newspaper for news and information about their local community, high school sports, city council meetings, things to do in their town, and yes, public notices. The proposed bill requires posting the notice on a third-party internet company's website, and there are a few big problems with this. First, all notices are already published and posted on a third-party website. It's the website our association created 11 years ago based on state law that has notices from all across the state. And let me be clear about this. Those notices are free. You do not have to pay to access those, and none of those notices sit behind any of our paywalls. They are free to users. It's very popular and has strong traffic. In fact, if you were to take out your phone right now and Google Tennessee foreclosure notices in Tennessee, guess what comes up first? Our statewide website, tnpublicnotices.com. It's taken 11 years and the efforts of all 130 newspapers in our organization to build that site up. So we wonder how a third-party website, brand new and built from scratch, how they hope to garner any sort of web traffic. It will take years and years. However, in this amendment, they did share part of their promotion plan. They're going to include the name of this new website in their newspaper notice. So on the one hand, they want to take notices out of newspapers, but on the other hand, they want to promote this new website in the newspaper. So we don't think this makes sense. The second big problem with the third-party website is it's not defined. Therefore, it could be a website that's not even devoted to public notices. It could be a random law firm, a tourism website, a restaurant website. Where does someone look to find these notices? And how does that increase exposure of people seeing the notices? And the third big problem is there is no pricing defined. Pricing for notices in newspapers is spelled out in state law, but it would not be for these notices. This means a third party can charge whatever they want. It could cost double, triple, or even more than the actual newspaper posting. So when you talk about saving money by eliminating print notices, customers may end up paying more in the end. This bill gives this third-party internet posting company unlimited pricing leverage. In addition, nowhere does it say that the third-party website will be free to the public. So a third-party website could theoretically charge Tennesseans a fee for something they now get for free. In summary, what this bill would end up doing is cutting way back on the exposure of the notices, taking money from local Tennessee newspapers, which puts at risk local Tennessee jobs, and handing the money off to some undefined third-party website. This bill hurts Tennesseans and Tennessee businesses, and we urge you to vote no. Thank you.
Thank you. And Mr. Millsap, you're recognized. You to say your name and who you're with.
Yes, sir. Can you hear me? Mark Millsap. I'm the executive director of the Tennessee Press Association, representing 131 newspapers in Tennessee, and appreciate Mr. Gould's comments. Exactly what he said. Everything applies here. This third-party website is not needed. We already have that. We operate it with our members. It comes. Just want to remind, by state law, the newspaper notice, when it goes in a newspaper, it automatically goes up to the newspaper website, and it's free to view. That content is free to view. And also the third-party website, tnpublicnotice.com. And again, that is free to view for people to see all notices, foreclosure notices, all the notices there. So that is in state law. Again, I don't think we need this third-party website at all because it's not defined. We're fine if it gets defined, a little bit better. We already have that third-party website too. We just feel this law is unnecessary. So with that, I appreciate a vote no on this.
Thank you. And we have two more to testify. Okay, I'm sorry, that's it. Without objection, we'll go back in session. Don't we have any questions? Okay, I'm sorry. Go ahead. And y'all are welcome to go back and forth.
Thank you. I guess in my discussion with folks about this bill, what we talked about was the expense to put it in the newspaper and that there wouldn't be the expense for it to be on the website. So what can you speak to as far as that? Because I thought I heard perhaps you said something about there was some place in the paper it could be put for free. Was that said, or am I crazy?
No, when you talk about rates for any public notice, state law Tennessee state law actually says that newspapers can charge their classified rate. If you think about the classified rate, it's not a secret rate or classified like some people have said. It's a classified section. So when you think of doing a garage sale ad, selling your car, selling your couch or whatever, it's by the word. Anywhere between 25 cents a word, 50 cents a word, things like that, it's by the word. So we are by law charging that. So when we talk about the rates and saving money, it's up to the person placing the foreclosure notice what they're putting in there. They can decide how much money they really want to spend. Now, some people put a lot of stuff in there to cover everything. Some people put the bare minimum, and our experts at the newspapers actually know what needs to go in there to have a legal public notice for foreclosures. So they help the person who might be on a budget and wants to save money be able to put onto what they put inside the notice. So really it's up to the person placing that notice, how much it is.
And I think the danger here is that there's no pricing defined for this third-party website. They could charge whatever they want, theoretically. And so that's a big risk. It's a lot of things are defined. What we charge, like Mark said, is defined in state law. There's no definition for this website. And without that, it could be more, theoretically.
Yeah, I mean, for me, this is one where, you clearly see both sides of the argument. The other side is how we get our information is changing, and we need to update how we get that information. That's why one of the things about stepping into this by doing it over a couple of years, getting people, familiar with where they're going to be going to get that information. But it is a tough one because there are both sides of that, but just how people get their information is really changing. And I don't want to see newspapers go by the wayside, certainly, but also, where do most people get their information?
Oh, I appreciate your comments, and you're exactly right. That's why we embrace the online side. Newspapers always said, we don't like online. That is incorrect. We embrace that. That's why we put them on the website for free to view, and that's why we have a statewide website. So there's 2 other places online for these public notices to go and for people to read them. But people still read the newspaper, especially a weekly paper in a rural county. That's where they get their information. That's where they get the high school basketball scores. That's where they get the city council meetings, all of that. People still read that. There's not reliable broadband internet in this state yet. It's coming. We understand that, and we embrace it as newspapers. But right now, people still read the paper. Thank you.
Thank you. And we do have 2 more to testify. We overlooked them. It's Amy Hazlett and Stacy Langford. And you are familiar with the process. If you'll just state your name for the record and who you're with, you'll have 3 minutes.
Mr. Chairman, members of the committee, I'm Amy Hazlett with the Tennessee Bankers Association, and TBA's membership includes all 121 Tennessee-based banks, as well as over 50 out-of-state banks. This legislation, as amended, would modernize the foreclosure process in Tennessee and reduce the financial burden placed on homeowners facing foreclosure by updating current law regarding foreclosure sales. The bill would reduce the number of times an advertisement of a sale must be published in a newspaper from 3 times to 2 times, and then 2 years later, reduce that down to 1 with no phase out. And that is similar to the law that's governing the tax sales of lands. It only requires 1 publication in a newspaper. It would also require foreclosure notices be posted online for 20 continuous days prior to a sale. And the amendment does 2 important things related to how the public would be able to locate the online listings of foreclosures. First, it would require that newspaper notices must include the website address of the company listing the online foreclosure. And second, it would require the Secretary of State's office to provide a listing on its website of all of the third-party internet foreclosure posting companies. And rather than mandate who that third-party online company would be, this bill would allow trustees to make that determination and select a company that meets their requirements. A newspaper would be eligible to serve as the company for both the print and online posting if they wanted to pursue that business model. And just a couple of key points that I would like to make. The bill will not affect notice directly to homeowners. They will still receive direct notice of the foreclosure sale by certified mail. It will not override the foreclosure publication requirements listed in a deed of trust, many of those out there still require 3 times in a newspaper. So for any deeds that have that language, they still would be required to publish in a newspaper 3 times. And that also banks are not responsible for the cost of foreclosure. It's the property owners who are. And while we have empathy for the difficulties of running a small newspaper business, we ask you to weigh that against the best and least costly method to provide public notice for a Tennessee borrower facing foreclosure. To specifically address the issue that was raised earlier about the expense of the website, it's not specifically mentioned in the legislation, but all third-party companies would be required, or the trustees would be required to comply with the Fannie Freddie cost market analysis each year, where they have to verify that. We've based this on what Arkansas has been doing for over 10 years. That cost has remained consistent at $275 per online posting. And based on, our many years of working on this issue, we have seen many kind of receipts for the newspaper ads in Tennessee. They vary widely, some a couple $100 per notice, some charge per line, some are a flat fee, but it could be as high as $1,500 or $2,000 for those 3 notices. And again, that's the responsibility ultimately of the homeowners who are facing losing their home. And for those reasons, I ask that you support this legislation.
Thank you. Ms. Langley, you're recognized. Okay, perfect. Any questions for Representative Davis?
Thank you. And I just wanted to ask the question, this essentially allows that trustee to determine, they still have the ability to post it in the paper if they so choose. If there is, any sort of situation where there is internet spottiness or that sort of thing, they have the ability to determine what's in the best interest of their client. Is that accurate?
And you're welcome to go back and forth on this.
Yes, that is. It would be a minimum. We set minimum requirements of 2 times and then 1. But if the trustee is in a rural area and feels like it would be better to provide public notice 3 or 4 times, that nothing in the law would prevent that.
And so it allows them to choose if they would like, after the, the stair stepping, they can still put it in the paper. They can still, do both. All of that is.
Yes, they could
Yes.
choose as many times as a newspaper. They would still have the requirement, though, of posting online. And the intent behind that is to get broader interest, not just in that rural community, but statewide across the country for anyone who would be interested. And that is another direct benefit to the homeowner, because the more interest in a sale, the higher the sales price.
Thank you.
Representative Johnson, you're recognized.
Thank you. Yeah. So I just wanted to make clear, I'm pretty sure I heard this, but there's still one time that they are required to put it in the newspaper. That doesn't go away, correct?
Correct.
Thank
We
you.
have no intent of ever coming back to change that.
Thank you. That's all the questions we have. We appreciate you coming, and without objection, we'll go back in session. Representative Todd, you're recognized.
Thank you, Mr. Chairman. Move previous question.
All right, the question's been called. Members, we're voting to send House Bill 1127 to full judiciary as amended. All those in favor signify by voting aye. Those opposed, vote no. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes, 1 no, and 1 present not voting.
The ayes prevail. House Bill 1127 goes to full judiciary as amended. And we'll go back to our firearms calendar, but on the way up, Representative Capley, we're going to clear out final calendar number 2. Without objection, item number 1 has been rolled to the first calendar of 2026 as House Bill 596. Item 2, House Bill 1231, off notice without objection. Item number 3, 1390, taken off notice without objection. Item number 4, 948, without objection, taken off notice. And do I have a motion and a second on House Bill 554 by Representative Capley? We got a motion and a second, and I do not show an amendment. And Representative Capley, I'm going to recognize you and pass the gavel to Chairman Farmer. So you're recognized.
Thank you, Chairman. Thank you, Committee. House Bill 554, also known as the Firearms Freedom Protection Act, creates a civil action against any governmental entity, official, employee, or agent that infringes upon a person's right to bear arms under the Tennessee Constitution or the United States Constitution. And that is all the bill does.
All right, appreciate that explanation. Looks like no amendments. So members, any questions for Representative Capley? And we do have testimony. So we want to go out of session, hear from our guests. All right, without objection. And we're looking like we have Jimmy Music and Patrick Powell. Jimmy, Patrick, are y'all around outside, inside? Perfect. Gentlemen, you know the drill. Have a seat. 3 minutes apiece. Introduce yourselves for the record. Thank you.
Good afternoon, Chairman and Committee. Jimmy Music, I represent the Tennessee Sheriff Association, Tennessee Association of Chiefs of Police. Want to start out by saying high regard for Representative Capley, understand what he's trying to do. Your law enforcement has no intention of trying to enforce a statute that a court has said was unconstitutional, regardless of what amendment we're talking about. Our problem comes into when you're looking in here about something like a search warrant that's later suppressed. That means that those officers may very well, acting reasonably in good faith, good intentions, to do their job. And I mean, the hypothetical would be we're hitting a house that maybe it's a drug dealer. And I know that this isn't the intent of the bill, but we have a valid warrant. It's later suppressed, or if it's not a warrant, it's an exception to the warrant that later we end up finding out that it was improper. Maybe the judge says that exigency truly didn't exist. The problem that we would have is that is not a law or regulation that a court has struck down that would say that this is not a violation. But for that drug dealer, if we took the dope and whatever firearms they had with them, we read this to mean that absolutely is going to be a violation of this statute. So that would create this new cause of action, punitive damages, along with potentially making those officers or deputies a felon because of the official oppression. So I'm happy to answer any questions that the committee has, but I mean, that's our chief concern, Mr. Chairman.
Mr. Powell.
Patrick Powell, Policy Director at TBI. TBI echoes the statements made by Mr. Music for the chiefs and the sheriffs. Same concerns. This is drafted overly broad. It would allow a number of different individuals, not just the aggrieved party, but anyone acting on behalf of that person to sue law enforcement in those circumstances. Obviously, y'all just heard Representative Fritz's bill to provide protections to firearms manufacturers. This is actually extending the ability to go after law enforcement. This also does not appear to have any kind of statute of limitations. I know Representative Grills has a bill on here about extending, statute of limitations on ability to go after sexual assault individuals and things of that sort. This one is indefinite. It doesn't appear that there would be any kind of statute of limitations. So an officer would be subject to being sued 10, 15, 20 years later for actions that he or she may have thought completely reasonable, that a judge may have even thought completely reasonable that signed off on a search warrant, as Mr. Music discussed. For those reasons and more, we would encourage the committee to oppose this bill.
Members, we have any questions for our guests? Representative Johnson, you're recognized.
Yeah, I guess one of the questions I have, and maybe this is for the sponsor, but I'll ask you guys as well. Why are we allowing punitive damages? That's
Either one of you gentlemen.
I don't want to speculate too much, but I mean, traditionally, so I'm an attorney by training, usually, so recovering. Usually when you see punitive damages, it's to incentivize attorneys to take these cases, because if the damages are nominal, especially something like this, then the punitives are used as a deterrent, as you would expect. But I mean, I don't want to.
And I obviously, same as Mr. Music, I can't speak for Representative Capley. Just looking at the damages that are actually written in there, it talks about $250 a day or more. As a former assistant district attorney, I can tell you, obviously, if an individual was arrested on a search warrant and taken into custody, you're talking possibly up to 10 days before they get a preliminary hearing. it could be another month or two before they're in circuit court and another month or two before a suppression hearing is heard. I mean, it is not outlandish at all to think that you are 3 or 4 months removed from a hearing where a search warrant may be overturned, and then that officer is on the minimum level without the punitive damages, subject to $22,000, $30,000 worth of damages. Obviously, with the amount that most of our law enforcement make, that is, in our minds, completely unacceptable.
Thank you. It does seem exorbitant to me, and I have great concerns. Thank you.
Think members, do we have anyone else? If not, I do have a question for either one of you two. Would it, and I'm sorry I hadn't been able to get with you on this one. This just kind of came to me as we're sitting here. Would this bill allow for a police officer like acting in his official capacity to be sued individually? Is that Mr. Music or Mr. Powell?
Yes, sir. Yes.
Okay.
The way it is written, it may not be Representative Capley's intent.
And I'll circle back around with the sponsor on this.
It would be our reading that
I
absolutely.
want to go ahead and ask the question and give him opportunity so he can be thinking about his response here too. So in that situation, as I understand it, if you're operating in your official capacity and then you're sued individually, would you then be in a situation where you'd have to individually hire your own attorney to defend yourself? And would the department cover that? That may be out of your scope there. I don't know. I'm just trying to figure out if something were to happen, an officer were to be sued by just a disgruntled defendant. Maybe he's mad because he's upset about being arrested or something, whatever. But he gets sued, and the next thing you know, lawyers having to pay all the attorney's fees. That's one thing that concerns me here. If that's the case, if not, then I'm not worried about it.
No, I think that's fair, Chairman. So what is common in these is by these I don't mean this type of suit, but in lawsuits that are filed that would include someone in their individual capacity, you're going to name them in both. So you're going to name the city or county they worked for. So that's going to bring in our insurers to help on that side. But in order to basically get them kicked out on the individual side, yes, they would have to retain their own attorney in order to fight that, is my understanding.
Okay. All right. Fair enough. Members, I have Representative Garrett, you're recognized.
Thank you, Mr. Chairman. You asked 10 lawyers the same question. You get 11 different responses on how they interpret what we're doing here. And so I want to kind of give you my interpretation of what we've discussed before when we met previously. I'm reading in section A, from section 1, section A, that it's not a violation of this section for government entity, official, employee, or agent to enforce the laws or regulations within the scope of the entity's officials, employees, or agents' authority, unless there's a violation of the Tennessee or state constitution, right? So in your example, you had said something about a suppression. So, or if there's a search warrant that turns out to be invalid for whatever, it didn't have probable cause, whatever the case may be, and there was some sort of seizure, say they seized this person's firearm. Later, there'll be a hearing whether or not that was an accurate depiction of the facts and whether or not that search warrant was valid. And if it's turned out that it's not, right? The way I read this is that the officer up until that point, and I think the sponsor could weigh in on this when we get back to him, is that the officer until that point has done nothing wrong or done nothing to violate the particular person's rights, because who decides whether or not this was an act of suppression or if the search warrant wasn't valid? It's the judge, right? And it's not up until that point that the judge decides. So if that particular firearm or whatever it was that was seized during this particular investigation and found that something along the way was not done properly, then that particular firearm at that point, once the judge determines whether or not that was an accurate search, whether or not it was an accurate seizure, whatever the case may be, at that point, the judge says, no, it's not. The violation, in my opinion, happens then if that particular firearm or whatever they suppressed or dispossessed from this person is not returned. That's when we would have problems. I think that's probably the intent that the sponsor is trying to entail, not the officer or anyone acting in their official capacity to make sure a crime's not being committed. But it's up until that point that if it's ruled that along the way that officer did do something wrong and the officer or the police department or the sheriff folks did not return those items that were suppressed, that's, I think, what we're trying to address. That items need to be returned immediately, because then you're violating someone's, I believe, constitutional rights when you don't return that property. Does that make more sense, or do you completely disagree with the way that I interpret that particular section of Section 1 under Subpart A?
Mr. Powell.
I mean, I think you kind of summed it up, Representative, when you said you can ask 10 different attorneys and get 11 different opinions. I don't think it's clear. I think Mr. Music, obviously, is an attorney. I'm an attorney. You're an attorney. The attorneys at the Bureau that have reviewed this with me have agreed with our kind of concerns that it is not clear that our officers could be, and our agents could be subject. And that is obviously gives us great concern. A court could rule that we don't want to subject any of our agents to that suit, and just hope that down the road that the Supremes side with your interpretation. So we still have concerns.
Thank you all for that.
My only 2 cents on it is that a fair interpretation? Sure. I think that what that tells me is we're going to litigate this for the next 5 to 10 years to find out.
Members, anyone else have any? And I have, yes, Vice Chair Davis, you recognize, and I have a question. One more
Okay, so I just have a hypothetical kind of situation for you gentlemen, just to kind of see if this is, so let's say the post office, obviously they scan their packages or whatever like that. They see somebody's got, somebody from California is mailing dope to Tennessee. They reach out to their local sheriffs, their task force, their DEA, all of them. They say, okay, we're going to deliver that package, but we're going to do it in a controlled way and see if this person accepts it and it's legitimately theirs, or, they refuse it. They don't know where it is. They go, they do that. That person accepts that package. They open the door. They see pot on the table, or they visibly can see a weapon or other things like that. They go in, have that person sign, waivers with regard to searching their apartment, home, whichever. Then they're charged criminally. They go before a judge. The judge says, you know what? That wasn't, I don't agree with that search, and throws it out. So then those law enforcement officers, depending upon when they go to court, I mean, I don't know. It concerns me that we're going to put our law enforcement officers in a position that they will have to defend themselves. This, in my opinion, works around that qualified immunity, and it will chill people from wanting to serve.
I just want to respond candidly that I've represented law enforcement down here for 13 years, and few people have so accurately depicted how we do a controlled delivery. So well done. But yes, I mean, that's the kind of situations that we're talking about in your controlled delivery hypothetical with a plain view search. When we open the door, or when the suspect opens the door, that's the kind of things that we're talking about here.
But depending upon the judge and that judge's discretion, they will determine whether or not that's a legal search or an unlawful search. And that's kind of where you get hung up, is that you could have a judge that leans one way or leans another, and that could really impact your law enforcement community.
Representative Davis, I think you're exactly right that what this will do, because your law enforcement, they take what you all do and we adjust how we operate. And law enforcement lives very much in a black and white world, and you need them to for most of the time, because when our guys operate in the gray is where problems usually occur. And so that's the problem with this one for us, is if you put law enforcement in the gray, it will have a chilling effect on how they do their job.
And I think that it's important to note that if officers are going beyond their scope of duties right now, there are recourses now to sue. I mean, whether it's a 1983 action on the federal side or on the state side, there are efforts out there to protect individuals from overly zealous or illegal acts by law enforcement. So we don't think this is needed, and it just makes things wide open.
Can I ask one more question? Can I ask one more? Is that okay?
Yes, Vice Chair, you may ask one more question.
Thank you, I appreciate it. So if there is a situation where law enforcement is not returning those weapons to an individual, what is that process? What is that procedure, so that we have a clear understanding of how that works, and so that we know what recourse people have currently?
I mean, a motion can be made depending on obviously, if it's a criminal case, the motions can be made in court to return that. There are civil motions, there are wrongful prosecution charges. I mean, there's all sorts of things that where officers are going overly zealous that there are legal recourses. I mean, I can't quote you verbatim the TCA at the moment, but again, there are state and federal protections for that. And so that's why we don't believe this is necessary and creates more problems than it ever begins to solve.
Any additional questions, Vice Chair Davis?
No, thank you.
All right, very good. Next on the list, I have Representative Stinnett. You recognize.
Thank you, Chairman. My question's been answered. Thank you.
All right, members, anyone else have any questions for our guests? And I just had one thing just popped to mind. One more. Asset forfeiture, stop, drugs, weapon. It's then dismissed by the administrative law judge. Then what's that situation look like? Have we already covered that?
No, sir, Chairman, but I mean, I can give you a real life example of a district attorney told me about, which is one where an ALJ believed that the state didn't meet its preponderance of the evidence burden, but yet we had a guilty beyond a reasonable doubt in criminal court. And so we actually had to give the money to the suspect's family because he was in prison. Because we got a guilty on the underlying charges, even though on the forfeiture side. But I mean, yes, and that example is because those things are parallel, and I don't want to muddy the waters too much and open up the forfeiture debate today. But yeah, I think that's a legitimate concern.
Okay. All right. And then maybe some questions for legal. I do want to get back into members. Have any more questions for our guests? All right. Thank you, gentlemen. Thank you for being here. Do we have anyone else on the list? That's fine. There's no one else on the list. Members, any objection going back into session? As a matter of fact, we're not in session yet. Representative Todd, you were on the list, Chair, in session. Okay, very good. Any objection going back into session, members? All right, seeing none. All right, back into session. Chairman Todd, you recognize.
Thank you, Mr. Chairman, and I appreciate you bringing this bill. And I think the crux has been touched on, at least one part of it, by Representative Garrett. And I think the other part is these are things that would violate someone's constitutional rights. That's all we're talking about here. Mm-hmm. And the statement in there, I think it's pretty clear. If it's not a violation, if they're doing it under their authority and a judge hasn't said this is unconstitutional. So I think they're very well covered there. But I think I think this is needed, and I appreciate you bringing it. There was a question earlier or a statement earlier about what it might I guess, morph into or could be interpreted into. Do you have a response on that?
Oh, Representative Kaplan, you recognize.
Thank you, Mr. Chairman. As far as I'm concerned, and the intent of this legislation, as far as what it could turn into, it's just a simple, matter-of-fact way for our citizens to, take an opportunity when they've been wrong, when their rights have been violated, to go back and to hold some of these people accountable. Now, like we had said before, and if I may, Mr. Chairman, we'll go on this again, there's nothing gray in this bill at all. It says in Section 1, Part A, Representative Garrett touched on this, it is not a violation of this section for a government entity, official, employee, or agent to enforce laws or regulations within the scope of the entity's officials, employees, or agents' authority unless the law or regulation has been determined by a court to violate either the Tennessee or United States Constitution. That is very clear. And the example that was brought up of them serving a warrant, and that could somehow, last time I checked, when somebody's serving a warrant, they're still a police officer. If they weren't, what would be the point of a warrant? I can't get there. To me, that just doesn't make sense. So we've got to give our citizens, our constituents, a way to stop the infringement on their Second Amendment rights, and that's all it is. But thank you. I know that was long-winded, Chairman. Thank you.
All right. Chairman Todd, you recognize.
Well, the only follow-up I would have is I was pretty confident that was your whole objective here. And every officer is sworn, and part of that swearing is that they will uphold the constitutions, just like we are. And so I think they're already obligated under this, even if we don't have this. So I think this does just give an extra layer of protection for the citizens. So it's very obvious everybody understands what the rules are. So thank you for bringing it.
Very good, members. Any additional questions for our sponsor? Yeah, Representative Capsule, you
And
Capsule, you
I
recognize.
have great respect for both of those gentlemen that just testified. We've had lengthy discussions about this topic, and I understand, like we mentioned earlier, you ask X amount of lawyers, you get X amount of opinions. But the point is, and I'm not going to beat a dead horse here, there comes a point in time where, you know, we're gonna have disagreements. We're gonna look through legislation, but we have drafted this and drafted it and drafted it and drafted it, and we've been working on it for Chairman Doggett had it before I did. This is language that came back from safety. I mean, we have worked and worked and worked. I talked to Chairman Russell. He's not in here. I would be amenable going forward if this, gets a favorable vote to maybe looking at an amendment to kind of making that even more clear about the law enforcement officers. I'm amenable to that 100%. That's not the intention. We're not trying to hem any of these guys up from doing their jobs. That's not it at all.
Okay, Vice Chair Davis, you recognize.
So, thank you, sponsor. So, because I think that we already have some statutes that do kind of cover these violations, right, of civil rights. So, what is it? What is this gap fixing, or what is it that I'm missing that it's covering or protecting that's not currently in statute?
Representative Kaplan, you're
It's simply creating a civil right action if the governmental entity, whatever that may be from the government, oversteps, goes outside of their scope, and infringes on your Second Amendment right. You can take them to court. That's all it does. It adds an additional step for once your Second Amendment's infringed on. You realize it's been infringed on. You've made however many proper steps to try to get your firearms back. There's been all kind of cases about this has happened. I can bring some later. I don't have them with me right now. That's funny. When someone's rights are infringed upon, there's got to be another way to. I mean, this is about an individual's rights, a person's rights, and to protect their Second Amendment. I mean, it's that simple, as far as I'm concerned.
Sure.
The intent, anyway.
No, and I appreciate that. And I'm grateful for that. And so the example that I was leaning toward was kind of where you talked about, a violation of this section of a government official, employee, or agent may also be punished as official oppression. And so that's where if you have someone operating like a law enforcement officer in their official capacity, obviously serving a warrant, that's the example that I was giving. But I would like some more clarification because maybe I can ask legal if they're, with regard to, kind of if this addresses any sort of other violations, civil rights violations that aren't currently covered.
No, you're not on. Still not on.
There it is. It works now. All right. Vice Chair, would you like to go out of session and hear from Ms. Fogarty?
Please.
Very good. Members, any objection to that? Ms. Fogarty?
Michelle Fogarty, Legal Services. So if someone violates your constitutional rights, you can currently file a Section 1983 claim to pursue that.
So as I understand the sponsor, their main concern is that their property is not being given back to them in any sort of timely fashion or whatever like that. Does that fall under some of those current statutes, or is this needed? Or do you, because I don't see that in this language, and that's what I'm confused about.
So there are currently in statute about if your property is seized and not returned, you can file motions with the court to get it back.
Because that would include money or jewelry or any other items as well, correct?
Yes.
Okay.
Members, anyone else, any questions for Ms. Fogarty before we go back in session? Representative Johnson, we're still out of session, sir. Representative Johnson, you recognize?
Yeah.
Yeah, we'll get back in.
Just real quick, building on the former rep's questions about, don't we already have anything in the code? So what you're saying that this changes is you currently have the ability to get your property back. This just gives you the potential to bring suit for punitive damages or anything else as well? or after you've gotten it back, or is this in order to get your property back?
Is that a question for the sponsor?
Yes.
Okay, very good. Members, any objection going back into session?
Short answer is yes.
So that's the difference. It does
Mhm.
allow you to pursue a lawsuit
Yep.
and,
If they go outside their scope.
okay.
Very good. All right. Next on the list, I have Representative Travis. Question's been called. Any objection? All right, seeing none. All those in favor of sending House Bill 554 to full judiciary, vote aye. Those opposed, vote no. All right, take the vote.
Mr. Chairman, you have 3 ayes and 4 noes.
All right, bill fails.
Thank you.
All right. That brings us to, if we could back up, members and folks, to item 2 on the firearms calendar there. That was by Representative Kiesling. Vice Chair Davis is also on that bill. Did you want to make an announcement?
Yes, thank you, Mr.
Or-
Speaker. We'd like to roll that to the first calendar of 26.
Very good. Members, any objection to that? All right, seeing none. House Bill 1210 is moved to the first calendar of 2026. Very good. All right, now, folks and members, we're going to be on final calendar number 1, which looks like we will be on item.
Well, we can start with 1. Let's make a motion.
I don't see Representative Grills here.
I think Jen said it. He wants to move it to the first calendar next year.
Very good. Item 1, House Bill 1301, Chairman Grills has been requested to move to the first calendar 2026. Any objection? All right, seeing none. First calendar 26. Item 2, House Bill 748, Representative Reeves will roll to the Hill. Item 3, House Bill 982, Representative Miller. Oh, excuse me, that's been rolled to the first calendar of 26. Item 4, House Bill 1050 by Representative Parkinson. Sir, you're here.
Second.
So you got a motion and a second. I'm looking at House Amendment 6153 as well. There's several amendments. There's 3, but that's the latest one.
Yes, sir. 6153. Yes,
All right,
sir.
very good. Members, we want to adopt House Amendment 6153 to House Bill 1050. Any objection to that? I need a motion and a second. Okay, very good. Got a motion. Any objection to adopting the House Amendment on this bill? Seeing none. All right, all those in favor of adopting House Amendment 6153 to House Bill 1050, say aye. Aye. Opposed, say no. Ayes have it. You're probably recognized on the bill as amended.
Thank you, Mr. Chair, and thank you, committee. Back in the late summer, early fall, I got several phone calls actually from a business constituent of mine. She owns a daycare, and she was complaining about another business that was just next door to her daycare in a strip center. And she was saying that there's always a lot of people hanging out there. There's been many calls to the same business. As a matter of fact, I had my precinct commander to pull the amount of calls that were happening at that business as of January. And as of January, there have been over 12 calls to this business for assault, for shootings, for theft, for other crimes, most of which were pretty hardcore crimes. I told her that we could not, because we weren't in session until January, there wasn't a whole lot that I could do. So I called our district attorney and told him about it. And the district attorney said, okay, we'll start sending folks in there. First, we'll send them a letter. They did send them a letter. Things kept happening. And then they said, we'll send some folks in there to do, some buys and this, that, and other. And he said, you have to be patient because this takes a little while. And before the fall was out, well, right around early winter, I got another call from another business that was 2 doors down, a barbershop. And this individual said, hey, man, is there anything that you can do about the other business that's causing all of this ruckus? And he said, because it's affecting my business. My clients don't want to come to my barbershop because of what's happening at this other business. And I told him that I had spoken to the daycare owner and that, I was going to be working on something in January once we come back into session. he called me again. This time he was asking me if there was any funding available to help him move his business. And I definitely didn't want that. One of his barbers ran into him, outside of all of this, and one of his former barbers, rather, he said, I had to leave that barbershop and go to work in another barbershop because my clients did not want to come to that barbershop because of what was happening at this other business. And then we got here, and I was fortunate enough to work with the DA's conference on crafting this legislation that would streamline the process for bringing those nuisance businesses to court to either remedy or the issues that's taking place there or close those businesses down. And since we started working on this legislation, there was a shootout at that same business. An individual tried to steal the sneakers of another individual at that business, and a shootout ensued. One side of the shootout, 6, 7 guys, had a 10-year-old out there with them. As they were in this shootout, they were ducking behind cars and shooting, and the 10-year-old was ducking behind the cars and standing up and looking as this shootout was happening. And shots are being fired the other way also. And I think I sent a link to that story to all of the members. I don't know if you had a chance to see it or not. And so that was happening while we were drafting this legislation. And the problem that this legislation solves is it streamlines the process so we can close these hubs for crime down faster and save these businesses that are adjacent to these centers, these hubs, and also save the property values for those residents that live in these communities also, because those residents are taking a hard hit in their property values also, which is, their largest investment. And Mr. Chair, the DA's conference is here. If you'll allow them to speak also, I'd appreciate it.
Yeah, that's great. We can do that. I believe Mr. Donovan was signed up to speak. Members, any objection going out of session hearing from Mr. Donovan? All right. All right, sir, just have a seat there, and you know the drill. Mr. Donovan, introduce yourself, and got 3 minutes.
Thank you, Mr. Chairman and committee. Mike Donovan, Deputy Executive Director of Legal Services and Policy for the Tennessee District Attorney's General Conference. I want to start out by saying, first of all, this did not originate as a conference bill. We worked with Representative Parkinson at his request to help him craft some legislation that he was trying to accomplish with the intent of this bill. The way it was described to me and to us was that there was much of a problem of establishing a pattern of behavior that would constitute the carrying on or the maintenance of a public nuisance under the current statute. Under Tennessee law currently, the Tennessee Attorney General, the elected district attorney general of the district, the county attorney, or the city attorney in each of those respective jurisdictions has authority to file civil proceedings to abate a nuisance, a public nuisance in Tennessee. Typically when a district attorney does it, it's related to criminal activity at a particular property location that's being maintained or carried on by the owner of the property or the occupant of the property, or those owners or occupiers are allowing others to come onto the property and they're fostering an environment of lawlessness. And so what I did is I took a look at the statute currently, and then we've proposed this amendment to provide for basically a prima facie per se nuisance after a certain number of arrests for events that occur at the same property that are unrelated in a certain period of time. And we've broken that down into 5 distinct categories of sexually related charges, such as prostitution, promotion, or facilitation of prostitution. Drug-related charges, which is what you would think it would be possession, sale, delivery, or manufacture of controlled substances. Assaultive charges, such as simple or aggravated assault, reckless endangerment with a deadly weapon, other types of assaultive behavior. Firearm-related charges, which would include, obviously, shootings or possession of firearms by prohibited people. And then finally, property-related offenses such as vandalism, or trespassing or juvenile-related offenses such as status offenses or delinquent offenses or contributing to the delinquency of a minor. What this amendment does is, and we actually patterned this after the current law in Georgia. Georgia has this in their code currently. It basically says that once any of those people that can file a nuisance action, the attorney general, the district attorney, the city attorney, or county attorney, provides that property owner or occupier of notice that there have been 3 or more unrelated incidents of any of those charges that I've just described to you, which includes arrest, not just calls for service, but arrest, which means someone's been taken into custody for where there's evidence of a crime. Then upon the 4th, if that gives the property owner, after that notice, the opportunity to abate the nuisance, that is to stop it, do something about it. Then upon the 4th arrest for any of those offenses, it creates a nuisance per se, so that we don't have to go into court and prove a pattern of behavior. The judge, it would be a presumption that the judge would order the abatement of the nuisance. Typically, that involves a temporary restraining order to shut down and padlock the property until the nuisance can be abated.
Very good. And thanks, sir. I'll let you go just a few seconds longer there. I thought you were about to finish up. No, it's good. I think the members needed to hear that to understand what was going on. Any questions for Mr. Donovan? All right. We ready to go back into session? All right, without objection. Thanks, sir. Appreciate you being here. Representative Parkinson, you recognize.
Yes, sir. Also, I think it's important to note also at the after that 4th incident, also the residents or other businesses inside of that zip code also will have cause to be able to go after their business because of their loss of either revenue or their loss of property values in that zip code too.
Very good. Members, any questions for the sponsor? Questions been called. Any objection? Seeing none. All right, looks like we're ready to vote to send House Bill 1050 as amended to full judiciary. All those in favor, vote aye. Those opposed, vote no. Everybody voted. Anybody want to change the vote? All right. Madam Clerk, you take the vote, please.
Mr. Chairman, you have 7 ayes and 0 noes.
Very good. House Bill 1050 is moving to full judiciary.
Yes, sir. Thank you. Thank you, Mr. Chair. Thank you, committee. Thank you.
Items 5 and 6 have been disposed of, folks. Item 7, we have House Bill 490. Representative Helton Haynes, ma'am, was here.
Oh, where'd she go?
She's here. Okay.
Her stuff is still right here. So.
Okay. She's probably fairly close. Okay. Yes, sir. Representative Travis, you recognize.
Hey, Parkinson. I'm glad it wasn't Ties for Turns Day.
He said he's glad it wasn't Ties for Turns Day.
Oh, okay.
Representative Helton Haynes, ma'am.
Motion.
You got a motion in a second, and I see House Amendment 5619. I think you'll need to adopt that, right? That rewrites it.
Yes, we do. It rewrites the bill.
Got a motion, and I have a second from Representative Travis. Thank you, sir. And members, we want to go ahead and adopt this House Amendment.
Aye.
Any objections? Okay, seeing none, all those in favor of adopting House Amendment 5619 to House Bill 490, say aye. Aye. Opposed, say no. Ayes have it. Now we're back on the bill as amended, and you're probably recognized.
Thank you, Mr. Chairman. Pursuant to McNabb versus Harrison, the Tennessee Supreme Court decided that Article 6, Section 4 of the Tennessee Constitution requires a municipal judge to be a resident of that municipality for a period of 1 year prior to the election. House Bill 490 amended rewrites the bill and does 4 things. It prohibits the disqualification or removal of a municipal judge who was duly elected or appointed to office prior to March 7th, 2025, and who is qualified for such office under the laws and interpretations in effect at the time of such election or appointment due to a residency requirement during the term of office to which the judge was elected or appointed. It requires that any such municipal judge be deemed a de facto officer whose acts, judgments, and decisions are valid and binding during the completion of the judge's term, specifies that the requirement for a municipal judge to be a resident of that municipality for a period of 1 year prior to election established by the Tennessee Supreme Court in McNabb versus Harrison on March 7th, 2025, shall apply prospectively and be enforced beginning with the next regularly scheduled election for any affected municipal judgeship, specifies that such does not exempt municipal judges from any other qualification or eligibility requirement. And with that, I stand for questions, but I also have the city attorney from East Ridge here to kind of give what brought this all about.
Representative, you want, is that a request? Does he need to be heard? Would that help the members
Yes, he
understand what's
does.
going on? Okay,
I
very
think
good.
so.
Members, any objection going out of the session? All right, seeing none. And we will hear from Mr. Mark Litchford, sir. And thank you for being here. If you would just have a seat there in either one of those three chairs, and when your light comes on your microphone, you're good to go. You've got 3 minutes. Just introduce yourself. And
Hi, members.
thank you.
My name is Mark Litchford, City Attorney for the City of East Ridge. This is an item that's come up as a result of a March 7 Tennessee Supreme Court holding in McNabb versus Harrison. This is the legislation being proposed here is what will basically provide guidance to all of the municipalities that had sitting judges that were qualified at the time of their election. Particularly in Hamilton County, there are 5 municipalities that have concurrent jurisdiction with popularly elected judges. The McNabb case was founded or held upon by a provision of the state constitution, Article 6, Section 4, that was written in 1870 at a time where it was identified as counties were districts and circuits. Since that time, we've had annexations that occurred, and multiple small municipalities have been come into existence. East Ridge, 1921, as a result of several annexations that happened in 1920. In the 1950s, you had some in Hamilton County like Red Bank, Collegedale, Soddy Daisy. And the problem that we're running into is if this residency requirement was not resolved by the Tennessee Supreme Court, you've got sitting judges that qualified at the time of their election. And we're now trying to get a resolution as to those judges. It provides due process to those that are sitting. It'll also eliminate any backlog that would occur as a result of municipal cases dealing with state criminal matter going down to the general sessions court. So there'd be a backlog in the general sessions. It will also address any claim for public defenders to claim that judges' decisions that were based on criminal violations, that those will be otherwise held valid. They are de facto judges, and the de facto judges comes about from a 2007 Tennessee Supreme Court case, County of Knoxville versus Jordan, where it was determined that qualified officials that were popularly elected at the time and were qualified can remain in that position until duly elected successor is appointed. And in this case, the legislation being proposed would provide that the sitting judges that were popularly elected at the time prior to March 7th of this year, prior to the McNabb holding, will otherwise get to hold that position until the end of their term. And then the residency requirements will be prospectively applied at that time. This legislation will impact around between 20 and 25 or more municipalities, and is highly supported by these municipalities to give guidance as to these sitting judges.
Very good. And thank you for that, sir. Members, any questions for our guests? Representative Johnson, you're recognized.
I think you cleared up my questions. I just want to verify, because my question was, this sounds like something that is Soddy Daisy, and Chattanooga proper, whatever. We're not talking about Shelby County and Hamilton County, that type of residence issue. And it's only for those people for the remainder of their terms. And I was also curious how many statewide it affected. And I think you said 20 to 25. Is that correct?
That's correct. Yes.
Very good. All right, members. I don't see any more questions. Thank you so much for being here. Without objection, we're going to go back into session. Representative Hilton Haynes, you recognized for any closing remarks?
Question on the bill.
The question has been called. All right, take it. Members, all those in favor of sending House Bill, without objection, all those in favor of sending House Bill 490 as amended to full judiciary, vote aye. Those opposed, vote no. As a member voted, anybody like to change the vote? All right. If you take the vote, clerk, please.
Mr. Chairman, you have 6 ayes, 0 noes.
Very good. House Bill 490 as amended is moving to full judiciary. Thank you.
Thank you, Mr. Chairman and committee.
Very good. And members, that brings item 811 by Chairman Grills. He's back there. All right, you got a motion? Second, you got a second as well. And you have House Amendment 3769.
That's what I have, Chairman.
Members, we want to go ahead and adopt that. Do I have a second?
Second.
Okay, you got a motion and a second. Any objection to adopting House Amendment 3769 to House Bill 811? All right, seeing none, all those in favor say aye. Aye. Opposed, no. Ayes have it. Now we're back on the bills amended. You're properly recognized.
Thank you, Mr. Chairman. I'm assuming they're paying you overtime for the work you've had to put in today.
Just enjoying it.
I bet you have. So this is a public safety bill that's kind of keeping up with the Trump administration's renewed focus on illegal immigration. What we're doing is anyone who is a victim of crime committed by an illegal alien will have a private right of action against any NGO that has assisted the illegal alien with housing in the community. And housing is defined in this bill as a long-term living accommodations or rental home and includes assistance with obtaining or signing a lease for an apartment or rental home. This does not include temporary housing such as an overnight housing, a storm shelter, a homeless shelter, warming shelters, and things of that nature. And this bill does not prevent NGOs from assisting aliens if that is their first core mission. This bill this just requires them to be more vigilant in their vetting and their supervising. So with that, I ask for a favorable vote.
Very good. Members, I have Mr. Julian Gordy on the list to testify here. Are you here? Julian, you're here? Okay. Members, any objection going on in session hearing from Mr. Gordy? Seeing none. Then we'll get back to questions for you, Chairman Grills, when we get back in session. Sir, you've got 3 minutes. Your mic's on.
Thank you. Thank you, Mr. Chairman and members of the committee. My name is Julian Gordy, and I am a Lutheran pastor, the Bishop Emeritus of the Southeastern Synod of the Evangelical Lutheran Church in America. I live in Franklin, District 65, and I'm urging you to reject this bill for several reasons. First, I think it's too broadly written. It leaves room for, I think, unintended and unfortunate consequences. It talks about housing services, and while we were just assured that those services wouldn't include overnight lodging and so forth, there are so many opportunities for people to serve their neighbor. Most of the time when people do those things, they are not aware of the immigration status of their neighbor. And I think it could really put at risk not-for-profit organizations and churches. For instance, could providing rental assistance or linens or cleaning supplies from a church's clothing closet be considered housing services? And the other thing I'm concerned about is what constitutes negligence in this bill. Negligence on the part of the organization or the congregation. Who gets to decide what negligence is? The bill appears to allow nearly unlimited room for interpretation there by elected officials and state agencies when it is already prohibited by federal law to take actions to assist somebody in entering or remaining in the U.S. without authorization. A second problem with the bill is that it works on the false assumption that immigrants are a drain on our resources and that they contribute to crime in our communities, when neither of those assumptions is based in fact. Instead, the reality is that immigrants provide millions of dollars annually to Tennessee's economy, and immigrants, including undocumented immigrants, are in fact less likely to commit crimes than citizens born in the United States. This is true on a national, state, local, and neighborhood level. It's true for both violent and nonviolent crime. I would hope that the Assembly would encourage your colleagues in Washington to fix a broken immigration system rather than punish vulnerable people. But for me, and I think thousands of people in Tennessee, the biggest problem with this bill is that it hinders people of faith and faith-based organizations from serving our neighbors who are immigrants. And in doing that, it threatens our religious freedom. This bill makes criminal acts out of acts of compassion and hospitality, acts which in our scriptures, people of faith are called to provide. I strongly support the separation of church and state and would never insist that you pass legislation.
Mr. Gordy, that's all the time there is. And we do have questions. And Representative Johnson, you're recognized.
Yes, I think this is one of my concerns. Earlier, I was in another committee and there was legislation that was in brought under the guise of respecting religious freedom. And so that is my concern here. Do you think that this is a threat to religious freedom? And how do you see it as a threat to religious freedom and the ability of our churches and religious organizations to do their calling, which is welcoming the stranger?
Yeah, that's exactly the case. I think we're called in Leviticus, the word used is to love the immigrant among us. And Jesus said the nations would be judged by how they welcome immigrants. So it's not a minor note in the Bible. And so it seems like this legislation is aimed at punishing organizations that are trying to do what their religion is telling them to do. And it's not something that harms other people. Just a bit ago, the committee here voted to protect arms dealers from some kinds of liability. And I would just suggest that churches and not-for-profit organizations be given the same kind of concern.
Thank you. I think that makes a lot of sense when you compare this to other things that we're seeing up here. And also, again, I appreciate you for bringing up the very important topics of the false assumption that immigrants are committing crime, because we know that far fewer immigrants than American citizens commit crime. The percentage is much lower. And we have laws on the books to take care of those who are here and are committing crimes. Is that correct?
That's right. And as I said earlier, there are federal laws that prohibit organizations from bringing or I think the word is harboring people who are not here with documentation. So I'm not sure what this will do except tend to make criminals out of not-for-profit organizations and churches.
Okay. And then you also mentioned that about the housing and housing services,
Yes.
also a concern
Yes.
with you because of the broad interpretation of that language and not being defined in the code.
That's right.
Thank you.
All right, seeing no further questions, we'll go back in session. We appreciate you being here today. Thank you. And Representative, we're back in session, and Representative Grills, you're recognized.
Thank you, Mr. Chairman. And I just want to reiterate, go back to the amendment on the bill or the bill itself. Section 2, as using this subsection, housing means long-term living accommodation and includes assistance with obtaining or signing a lease for an apartment or a rental home, but does not include temporary overnight housing such as that provided by a homeless shelter. So the remarks that the gentleman just made, we're talking about with a church, if that's what their goal is and that's their efforts to make sure that homeless individuals have a place to stay warm overnight, this will not be impacting them.
All righty. Any questions? And we do have a question for Representative Johnson. You're recognized. And you're free to go back and forth.
Thank you, Mr. Chair. Again, the concerns about religious organizations or churches beyond the idea of the terms housing and housing services, do you not see the potential for there to be a problem here when it comes to religious freedom and also religious organizations being able to carry out their religious beliefs?
Oh, thank you, Mr. Chairman. I don't know anyone that would think that their religious belief would be helping evade, bed, skirt the law, hide someone when they are breaking the law. I don't believe that would be part of anyone's religious tenets.
Does this bill say hide? It says house. It's not hiding.
And if you help someone get a lease or for an extended period of time, you are helping them, you're enabling them to break the law. And therefore you are responsible if that person commits a crime.
But not based on your faith and belief.
Do we need to go out of session to ask legal the question on housing, or you good?
I don't think we need to ask a question on housing. It goes back to religious your religious beliefs, your faith, and what it guides you to do, and your religious freedom to practice your faith.
We really just see things different. You and I do.
All righty, no further. Representative Todd, recognize.
Thank you, Mr. Chairman. I think one of the most critical pieces of this legislation is the last sentence in C and the words, if the charitable organization's conduct in providing housing constitutes negligence, gross negligence, or willful and wanton misconduct. There's an if there. They're not guilty by just helping somebody, but if it meets that definition by providing this long-term living accommodation, that's the problem. There's many things that we have on our books that outlaw things that maybe some religions might think are okay, but they're infringing on someone else's rights. And so it's not okay under the law. And this, I just appreciate you bringing this. I think that's just the comment I wanted to make to summarize that. Thank you.
Very good. No other questions. We're voting on House Bill 11 to send to full judiciary as amended. All those in favor signify by voting aye. Those opposed vote no. Has every member voted? Does any member wish to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 5 ayes and 1 no.
The ayes prevail. House Bill 811, full judiciary as amended.
Thank you, Mr. Chairman and committee. Y'all have a good rest of the afternoon.
Thank you too. That brings us back to item number 2, House Bill 748. Do we have we got a motion and a second, and we do not have an amendment. Representative Reeves, you're recognized on the bill.
Thank you, Mr. Chair. No, we do not have an amendment, although reading the bill might believe you to make you think we did. I had to get it out of caption jail earlier. This is a one-line bill, and it was brought to me by a local municipal court judge who is part of the municipal court organization. In 2004, the Tennessee legislature adopted the Municipal Court Reform Act, and it said that $1 shall be forwarded by the municipal court clerk to the state treasurer for deposit in the administrative office of the courts to provide training and continuing education courses for municipal court judges and municipal court clerks. In the last 20 years, that power of $1 has declined quite a bit. And we are just looking to raise that to $2 and still provide that training and continuing education for judges and clerks.
Thank you. Members, we got any questions for the sponsor? Seeing none, I do have one question. Did you get visitation rights to caption jail, or how did that work?
Haven't fully fleshed that out, Mr. Chair.
All right. Members, we're voting on House Bill 748 to send to full judiciary. All those in favor signify by voting aye. Let's try it on the board. Those opposed vote no. As all members voted, does any member wish to change their vote? Madam Clerk, takes a vote.
Mr. Chairman, you have 6 ayes, 0 noes.
The ayes prevail. House Bill 748 goes to full judiciary. Congratulations.
Thank you, Mr. Chair and committee.
Thank you. All right, members. Hold on just one second. Okay, the last thing we got to worry about is House Joint Resolution number 7. Without objection, we'll send that to the clerk's desk. Would anybody be recognized? Seeing nobody, I do want to thank our legal staff, our research analysis, my assistant, the sergeant at arms, the clerk. Appreciate you all. Everybody that shows up in attendance every week, thank you. All of our witnesses, we appreciate the time that you come down and testify. That means a lot to us on the decisions that we make here. And to all you cool cats and kittens that are watching us online, we appreciate you. Without objection, we'll be adjourned subject to the call of the chair.